I will kick us off. I am Maggie Grover. I have been practicing employment law in California for years. I come by these gray hairs honestly. I am currently a solo with my own law firm, Grover Workplace Solutions, and I do both plaintiff and defense work, employer and employee. I had thought that I was going to move more into mediation, and then COVID hit and there was not the time to get out and meet and greet, and so now I've decided maybe I'll become a flight attendant. Well,
good afternoon, everyone. I'm Paul Garrison, and I'm also an employment lawyer turned neutral, so I do mediation and arbitration, and I'm proud of the fact I'm now enlisted with JAMS. So that was a long time coming. My employment history is, well, Maggie's more of a litigator. I spent a lot of time as an in-house lawyer for Wells Fargo, handling employment and labor matters and other corporations before hanging out my shingle as a neutral. And so I'm happy to be here and working with Maggie on this presentation. So keep it coming.
all right. So we're going to talk a little bit about arbitration agreements in general. I don't know what's your experience? How many of you have been doing employment law for more than 10 years? Everybody except Anthony.
I haven't practiced that long.
All right, so employers have been trying to require employees to sign arbitration agreements at the outset of the employment for years. And every time the employers try to do that, employees challenge it or challenge the arbitrability, the enforceability of the arbitration agreement. And we go back and forth. And recently there have been two recent decisions that we will talk about at the end of the program that affect the arbitrability of actions under the Private Attorneys General Act of California. And I know that's what you're all here to discuss, but we just want to give you a little bit of the background necessary for it. The first case in California that was really seminal on the enforcement of arbitration provisions was Armendariz, which many people say Armendariz, but I had a person down the hall from me who her last name was Armendariz, and so that's how I learned how to say it. And I've had judges say, well, is that really how you say it? Well, it's how I say it. Anyway, that arose in the situation of a Fair Employment and Housing Act claim, discrimination claim. And they ruled that there have to be fundamental fairness in an arbitration agreement in order for it to be enforceable. And fundamental fairness was defined as the agreement must provide for a neutral arbitrator or arbitrators. Now, employees will often argue that employers have the advantage in the arbitration arena because they can become repeat customers for arbitrators. And so some employees will just say you can never have a fair and neutral arbitrator because of the ability or the threat that the employer will be using that arbitrator over and over. For small businesses, which is the bulk of my practice, that just doesn't happen. If they have one arbitration, then they tiptoe around any kind of employment dispute and try to settle it before the person gets involved, or they put up with somebody for a long, long time. I also think that the plaintiff's bar would reject arbitrators if they suddenly heard that a particular arbitrator was leaning heavily in favor of the employer. The arbitration agreement must provide for more than minimal discovery. I have seen arbitration agreements enforced where there is a finite amount of discovery that is allowed, but the agreement says the arbitrator has the ability to grant additional discovery if it's necessary to flesh out the case. Absent that kind of a provision, I think that any limits on discovery would be tricky and would be a strike against having the arbitration agreement enforced. They must require a written award. I can't imagine an agreement that doesn't require a written award. They must allow for all types of relief available in court. And I kind of wondered how any of the PAGA restrictions got past the Armendariz decision because they're saying, you can't recover under PAGA. There are contracts that were written. You can't recover under PAGA. And I never really saw that challenged that way, but I think probably the employers were arguing that the individual can get all of the recovery available to him or her, even without the PAGA recovery. Excuse me. The agreement cannot impose unreasonable costs on the employee. Nothing against jams, but the filing fees in jams are way out of line with filing something in court, even sometimes for the employee. And I think that that can be a problem. But again, most of them have the ability to waive if the plaintiff does not have the ability to pay for it. And then the agreement may not require the employee to pay any arbitrator's fees or expenses. So a filing fee is different than an arbitrator's fees for expenses, which would be the daily fees and the costs of perhaps getting copies of exhibits or paying a court reporter, although that's generally pushed off to the parties who request the court reporter. The courts have also looked at unconscionability and discussed that there are two types of unconscionability, procedural and substantive. And both factors need to be present in order to find that an arbitration agreement is unconscionable. They don't need to be present to the same degree. It's a balancing test, a yin and yang. The more substantively oppressive a contract is, the less evidence you need of procedural unconscionability in order to find that the agreement is unenforceable. So, what are some of the things that are looked at to decide if an agreement is unconscionable? Is it fair is really the bottom line. Mutuality. Are potential employee claims given the same treatment as claims the employer is likely to bring? That has arisen many, many times when an employer tries to say, well, if you breach your non-disclosure, your confidentiality agreement, that we can run to court and enforce it, but everything else is going to have to be resolved through arbitration. Now, I think under the California Civil Code, employers can get the same result by saying if there is something, there's a provision that allows you to go into court if there's an immediate irreparable harm, and you say, well, stealing my trade secrets and my confidential information and using them is an immediate irreparable harm, and so I need a restraining order, and you get the restraining order, and then you go back to the arbitrator to decide the damages. So you get the same protections under the California Civil Code. So employers don't need to write the agreements that way. Excuse me. The arbitrator selection process must be neutral. If it's not neutral, if the employer gets the first and last strike from a panel, that's not going to be neutral. Limitations on available discovery, we've talked about that. Limitations on recoverable damages. I have seen arbitration agreements that try to say emotional distress is going to be capped at X, or you're not going to be able to recover your attorney's fees, or your attorney's fees are going to be set at $250 an hour instead of what the current going rate is. That's not going to be accepted as a fair arbitration agreement. A lack of meaningful opportunity to negotiate or opt out. There was a period of time where if you made the employee sign the agreement at the outset of the employment, but told them that they had 5 days to opt out, that would be acceptable as not being unconscionable. What's that? Not unconscionable? I guess it's conscionable, as a fair agreement. But the courts have since decided that that kind of thing is not going to automatically save your agreement. Another problem is the employer's ability to modify the agreement unilaterally. And you see this in employee handbooks all the time. Here's this arbitration agreement that they signed, and at the front of the employee handbook it says, we get to modify any provision of this agreement, of this handbook at any time, except for the at-will employment provision. And that's where the way a lot of them continue to be written, because people don't understand that they can't change the arbitration provision. And unfair surprise and deceptive tactics, giving someone a 10-page tiny print document or telling them they have to look online for the terms of the arbitration without telling them where it's going to be found online. There was a time where any reference outside the contract would be found to be unconscionable. That has since evolved a little bit, and you can give them a citation and a link, and that's going to be okay as long as they have easy access.
Do you think, Maggie, would you advise your clients to have a separate agreement? I've seen that now where it used to be kind of embedded into, say, the policy itself, the handbook itself. And now I'm seeing where there's almost like a standalone agreement. Do you think either are good or?
I strongly prefer a standalone agreement. I prefer a standalone agreement that has a provision, just a one line that's in bold that says, I understand I'm waiving my right to a jury trial. I still think it's a good idea to have them say, to give them the opportunity to opt out, although that is not required under California law. I still find that 98% of employees, when they are accepting a job or first new, even if there's a provision that says your employment's not going to be affected if you opt out, and if you want to opt out, initial here, they will not. They will just go with the arbitration agreement. Many of my clients have it as part of their acknowledgement of their employee handbook. So the acknowledgement turns out to be 4 pages long by itself, because it's got, you're going to have to sign a confidentiality agreement, you're going to have to sign this arbitration agreement, you're going to have to acknowledge the receipt of the handbook and some other things. But I don't like it buried in the middle of an employee handbook. In fact, there are some decisions out there that say putting it on page 36 of a 52-page handbook is not sufficiently drawing the attention to it, even if there's like a hey, look at the arbitration agreement that you're signing as part of the acknowledgement. But yeah, I like it. And today, so many employers are going to online agreements, and they can just pull it up and click, 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 and initial, and then it's stored for the employer. That's just the way things are going. Anything else you think I've missed?
Oh, no, that wasn't a miss. I just thought it would be good to get your opinion on whether you think it should be standalone or not, but it looks like you got a question.
Yeah.
It's not a question, it's more just an interesting point. On the unconscionability, there's a current California Supreme Court case that's being decided. It's Ramirez versus Charter Communications. I only know about it because I helped write an amicus brief in it. But they're looking at the Armendariz, however you
Or
say it.
Armendariz, or however it is.
They're looking at the unconscionability standard because 2 different divisions of the same appellate district found the exact same arbitration agreement. They looked at the same.
One enforced it and one didn't.
One found it unconscionable and the other didn't, and it's the exact same agreement. So
And
there might be a huge rule on this
there might be.
coming out.
There might very well
Who
be.
knows?
And again, I think it needs to go back to being fair. At one point, there were cases that said if you gave the employee an opt-out, because you have to have both procedural and substantive unconscionability, if you gave them that 5-day right of opt-out, you had erased the procedural unconscionability. And that stood for 5 or 6 years before some appellate court decided, oh no, that's not. And so it evolves all the time. And this is going to be another course case that we need to look at, and
If
since
it's
we
published. If it's published.
yeah, and since we cannot,
Wasn't that the Supreme Court, they took an amicus brief, so it must have been.
They granted review and the parties have submitted briefs, so
yeah.
I don't know.
So we'll probably see it in 2025. But yeah, it's, if you change your agreement to comply with one of the recent decisions, have you then violated the provision that says you can't change the agreement? It's all very iffy at times to me. A lot of employers simply refer to the JAMS online agreement or ADR's online agreement or AAA's online agreement and say this is what it will be, and those change regularly because those entities do keep up with all the latest decisions and tweak their arbitration agreements so that they comply.
Well, the next session,
Yeah.
What if there were a change in the law and you have to change your arbitration agreement to be compliant? You offer to change it, the employee said, we want to change it to read as follows, to comport with law. And the employee says no.
You know, I've never run into that case. I would say that the employee that's saying no is probably going to be a problem employee, but
But already.
But I think that you just have to accept that, and then when you
argue
are
that it was a mutual agreement
right,
to not follow the change in the law, and therefore that should not
No, you can't.
affect the enforceability.
that would be an interesting argument. I think that I would make the argument rather that we offered and tried to make it comply with the law, which particularly if it is more favorable to the employee, as the changes usually are, that I would then argue that the employee declined that offer and should be stuck with arbitration under the old agreement.
Or your arbitration agreement is unconscionable and it doesn't exist. And the employee did quite well saying, I'm not signing a new one.
That would be what the plaintiff would be arguing. So there you have it.
But I don't think.
And then there would be the question of who gets to decide it, the arbitrator or the court.
I don't think you can agree or stipulate or do anything to agree that the generally applicable law doesn't apply to you.
Well, I don't think that's the argument I would make. I would make the argument that we offered to comply and they declined, from the employer's perspective.
One part of the analysis too is this one unconscionable term, or maybe there's a few, does it rise to the high enough level to where the whole agreement is unconscionable, or can I sever these out?
Can you carve out
And-
those
and
provisions?
Then maybe if you think I can sever it, and you have a severance clause in there,
Yeah,
maybe you don't bring it up at all to the employee and just,
until you've got 6 or 7 things that you need to amend.
yeah, exactly.
Well, the next section is pretty interesting. It's a creature of California law, the Private Attorney General's Act. And I've always thought it was pretty rad for the state to have to allow individuals to be able to act in the role of the government in terms of trying to right the wrongs pertaining to wage and hour violations. I'm assuming that everyone in here has heard of the Private Attorney General's Act called PAGA, and it was enacted in 2004 to give these aggrieved employees the right to file these actions basically on behalf of the state. And because there's so many of them, the state really doesn't have the resources to manage and pursue all of these claims. And this type of action derives from the old school days when someone could bring an action on behalf of themselves and the king. It's this long, Latin phrase that I will spare you, but basically I thought it was pretty cool that someone could do this. What's really important in these PAGA claims is that you have to get right on to make sure that the notice requirements are met. There are a lot of procedural aspects to this, which we'll get into, to ensure that you're, properly noticing the employer and giving them a time to cure and that sort of thing. But at the end of the day, if there is a recovery, 75% of it goes back to the state and 25% of it goes to the aggrieved employees. So it's a representative action. It can be for that individual to recover as well as on behalf of other aggrieved employees. So for example, if there were waiting time penalties because the employer didn't pay wages in a timely manner, and if there were meal and rest periods that were violated. So any number of wage and hour claims could be brought as a PAGA action. And if a PAGA plaintiff is successful, they can collect attorney's fees and costs. So, it's definitely something that employers should be taking seriously. And so, again, before the filing of a PAGA action, the employee has to give written notice to the state. There's a $75 filing fee, and the employer has to be notified by certified mail. And if the notice is deficient, the lawsuit can be dismissed. So it's very important to get that done and correctly. And if the state declines to investigate or respond within 65 days of receiving proper notice, then the employee can file a civil lawsuit seeking PAGA penalties.
And you can now file the notices with the Labor and Workforce Development Agency online.
So that's
Better yet, you can search the notices that somebody
Yes.
filed online and find out if somebody beat you.
I have 3 cases where people forgot to do the search.
Judge, will you
Well,
say
they were
something?
stitch.
Oh, you're just stretching. Okay. So there are three categories. So we already mentioned the first one where there's some specific labor code violations under the California Labor Code. And then there's also the health and safety violations of Labor Code Section 6300. And in those cases, you have to notify not only the employer, but the Division of Occupational Safety and Health. The division is required to investigate the claims. And if a citation is issued, the employee cannot file a civil action under PAGA. If no citation is issued, the employee may appeal to the Superior Court, directing the division to issue a citation. And then you've got a catch-all provision for all other labor code violations. And these deal with like the, technical errors. I actually had this where a client didn't have the right name or address correctly on the on the pay stubs. So it was deemed a technical violation. And so that can give rise to a PAGA action. And of course, every employee's pay stub was incorrect. So that was a big problem. But the employer does have a little bit over a month to cure that violation. And hopefully they do. And the employee, if they don't believe that that cure is sufficient, can go back to the state and complain to appeal that decision. And then the state has like 17 days to respond to that appeal. The important thing is employers are just not given an indefinite number of times to just like violate the law and then cure it and violate the law again and cure it. At some point then it's, that could be problematic for the employer. And there may be some finding, I suppose, that we're just going to penalize you in the, at the umpteenth time that you violated the wage and hour laws.
It is surprising to me, particularly in the small employer arena, how many small employers will not pay any attention to their PAGA violation notices. And some of the claims could have been remedied. For example, I had one client that had changed physical locations, but had not notified its payroll issuing company. So all of the paychecks still had the old address on it. And it would have been just a snap to issue, they would have had to issue a year and a half's worth of paychecks by the time, or something like that, to all of their employees, or reissue amended pay stubs. And they didn't do it online, which was silly, but that, because it's per employee, those penalties rack up pretty quickly. And the employees individually can get the same penalty or a similar penalty under Labor Code 226 for a defective pay stub. And most of the PAGA claims are echoing individual penalties that the individual employee can recover, and that can be recovered as a class action. And so it ends up being a fair amount of stacking once you put all of these together, and some judges will let you do a lot of stacking, while other judges will limit your stacking of these things.
Yeah, that's a very good point. Why do you think that the smaller employees they're so important employers? Are they just busy, or is it just so many different
They're
things?
busy, they may not understand what this notice means,
And the gravity of
and the gravity of it.
Yeah.
Somebody's complaining to me about somebody's complaining to the government about me. I've got, this government and that. Yeah, exactly. I'm dealing with my taxes and crying out loud.
So I think it is easy to get caught up as an employer, and so I think we, those who are representing employers should really make sure that your clients are aware of these things, and so that they don't give them short shrift. But ultimately, if the employees can appeal the determination if they believe if the employer has cured but not satisfactorily, that can be appealable to civil court. So how much time do you have to file after a violation occurs? You have, there's a 1-year statute of limitations, and that, as we all know, can fly by fairly quickly. So, however, that statute would be told if proper notice is given and the employer exhausts their administrative remedies. So, this is a representative action, so it doesn't need to be certified like a class action does. So, Maggie was referring to those civil penalties and how they rack up pretty quickly. Here in that second paragraph on the slide, you can see that the penalties are equal to $100 per employee per pay period for the initial violation, and $200 for each paid employee per pay period for each subsequent violation. So if you have numerous employees and they're covered, that can add up pretty quickly. So,
And when you look at the statute of limitations, it goes backward 1 year from the time you filed with the Labor and Workforce Development Agency, but it remains open going forward if you continue to have the same violations until the case is resolved or you change the way you're doing things. So it could end up being a 3 to 4 year period, given how long it takes for things to wend their way through our courts.
wow, that's very important to know. So a trial court must approve any PAGA settlements, and a copy of the proposed settlement must be submitted to the court and the Labor Workforce Development Agency online. So that's kind of a overview of PAGA claims, and questions on that?
Not a question again, sorry.
Oh, comment.
One thing I see a lot that faces employers is the plaintiff's attorney will file a class action first on the wage and hour violations, and then they'll send out the PAGA notices. So the first notice the employer will get is the class action, and then they'll send in the notices to the LWDA, and then later on, once they've gone through the administrative process, they'll amend the complaint and add the PAGA later. So
I'm seeing yet another twist on that, that the PAGA claims are filed in a different court. than the underlying claim. The PAGA claims, if the underlying wage claims, if there's diversity, the wage claim class action will be filed in federal court, and then they'll file the PAGA claim in state court so that the employer is defending on two fronts, the exact same elements of violations. And that's, I've seen that in 3 cases very recently. I don't know if that's a trend or just,
You don't even need diversity, you just need to make a fair labor standards overtime claim.
that's true. That's true.
What
And
do you-
if I had a misclassified employee, that's exactly what I would do. This employee is not exempt, so yeehaw to courts.
What do you do with that circumstance? If
Well-
state and federal, same thing.
If there
You
is,
call James.
if there is diversity, I have
Shame.
removed the state court action and tried to join it with the federal action. Paul's right, you call somebody and try to get it settled rapidly, because I think part of it is a tactic to let you know that you're gonna have a lot of expenses. And there may be inconsistent determinations between the 2 cases. If there is an arbitration provision, we'll get to that, but you can stay the PAGA claim until the arbitration of the other action. I've tried to stay the PAGA claim until the resolution of the underlying class action when there's not an arbitration provision, and I'm getting, oh, we can defeat that from the plaintiff's bar. I'm not brave enough to handle one of these on the plaintiff's side.
A PAGA,
A PAGA.
we need to talk. Send them to me.
We need to talk about other things anyway. Marcia and I have known each other for a long time, and she is one of the best actresses that the law has ever produced.
Thank you. You are not so bad yourself.
So I somehow managed not to get in a slide on Iskanian, which is the first time that the California Supreme Court decided anything about arbitrability of PAGA claims. In Iskanian, the plaintiff had an agreement, an arbitration agreement that said anything arising out of the employment is going to be subject to arbitration. And by the way, I agree not to bring a class action or a representative action. And so the employer said, haha, can't bring a PAGA claim, gotta arbitrate. And I don't know how much they spent on defending that and fighting it up to the California Supreme Court. But when it got to the California Supreme Court, they decided that one could not strip an employer could not strip an employee of his or her right to bring a representative action. And that the action really was not held by the employee. The cause of action was held by the state attorney general. And so the agreement with the employee didn't bind the state attorney general. And so those shoes were still empty, and the employee could step into them and represent all of the aggrieved employees, so long as the employee was indeed an aggrieved employee. And by the way, who can tell me who that is?
Is that Becerra?
Rob Bonta?
Rob Bonta.
Rob Bonta. Your attorney general. Looks to me like he's too young.
Sarah's like Department of Transportation or something.
Yeah, he
Not
was.
too much.
Yeah, he's up there.
Yeah, he
You're
was.
gonna get disappeared.
Yeah, I think it was 3 years ago, a group that I belonged to gave him an award, and then he just,
Oh,
yeah. I don't remember, how long has Bonta been there? A couple of years?
Since the Sarah left. I think.
Yeah.
Bonta was a legislator when I
Right.
worked for the Ledge Council.
Well, when I started practicing, there was no PAGA. And people that didn't really do employment law on a daily basis would try to include penalties that were only recoverable by the Attorney General. And I would say, that's the Attorney General's, you can't. I had never, ever, 35, 6 years of doing this, never seen the state attorney general or any local authority try to enforce the civil penalties that are available to the government. Never seen it.
Well, that's hence the statute.
Hence the statute. And there have been some playing with the statute, but boy, there was a lot of pushback when it came in.
But now the DIR has a PAGA unit, PAGA enforcement unit.
Right. Have you seen them actually do anything? I know some of the lawyers there. I think there's some good lawyers there, but
I interviewed with them, but I couldn't take their offer, so.
yeah. No, I have a friend who's working there. She's a great lawyer. She's seasoned, and she must be doing something, but I think they probably are picking impact cases. So
Yeah.
my little small employer clients are never going to be hit.
Yeah, they're picking cases where it's agricultural employees, I think, or factory employees.
Well, it used to be that the enforcement agencies would pick a particular industry and work that industry for a year or two. For a while it was garments, and then it was restaurants, and then there was a time that they were doing like automotive work, like people that work on cars and change tires. But by and large, it's industries where either there are a huge number of employees and the industries are smaller businesses, or there are a large number of employees that are from outside of the United States and need to have that enforcement because it's unlikely that they will be finding a lawyer or seeking legal advice because they know that many of them may not be here lawfully, and they may not understand that they have every right to get paid the same as somebody who is here with all of the appropriate documentation. So now that I've rambled on a completely side note.
No, that's good. Let's talk about the Viking River Cruises case versus Mariana. So the plaintiff in this case sued Viking, her employer, Viking River Cruises, and was seeking penalties under PAGA. And the employer filed a motion to compel arbitration, to get everything in arbitration, and the trial court denied the motion to arbitrate. And the Supreme Court affirmed that motion, denial of the motion.
This is the United States Supreme Court.
The United States, so that we're going from state to feds, highest court. And this is an interesting case because there's a preemption issue here where the Supreme Court said that, under the Federal Arbitration Act, that you can be compelled to go to arbitration where an employee's right to bring individual claims through PAGA has been waived. And there's also, it's a preemption of the state law that says that PAGA claims can't be divided into individual and representative actions, where the parties have agreed to arbitrate the individual claims. So if a party goes in and it arbitrates individual claims, then that opportunity to have a representative action can be lost if the individual claims are arbitrated first. So it's really kind of carving away, I would say, the individual's right to serve as the representative plaintiff for PAGA because of the federal law, the FAA here, that's preempting the state laws of states like California. So it's a really important case in this regard and shaping this body of law with respect to arbitration. You want to add anything?
I'm sorry, I don't understand. Viking sought to compel arbitration, which was denied. So they can't arbitrate.
No, it was not. Viking, they allowed arbitration.
I agree, it sounded.
Yeah, I think that the point must be, I think it's misstated in the slide.
They denied the right, so the trial court denied the motion to compel
I think that is
arbitration.
misstated in the slide.
Oh, My apologies.
No, it's probably,
Well, let's look
Yeah.
it up.
It's really pushing, it really stands for, now you're gonna be pushed to arbitration. You can't like,
Your
yes,
individual
yes, exactly.
once that is arbitrated.
so when the employee who had signed an arbitration agreement got dumped into arbitration, the bottom line is, and he was going to be put into arbitration because the California statute that said I can't force someone to file, to sign an arbitration agreement at the outset of their employment, that was preempted by the Federal Arbitration Act. And so, yes, Moriana had to arbitrate claims. And once in arbitration, they lacked standing to pursue the exterior claims under PAGA, was the way the Supreme Court analyzed that.
So now that opportunity to have a representative action can now be lost because you're arbitrating that individual aspect first. So that's kind of the carve back as I see
Now
it.
the individual goes and has an arbitration decision that holds that she was violated.
So this is Viking,
Yes.
and
Suppose they go
the
out.
next case,
Okay, but no, let's stay with this for a moment.
okay,
They go out and they get a win. The arbitrator holds that they are an aggrieved employee. The employer is ordered to pay their back wages.
right.
What happens now with the PAGA penalties?
Under Viking River cases, they lost the standing when they were pushed into arbitration under an arbitration agreement that said they could not pursue representative claims. They had to,
But
they could only,
And they didn't.
under Iskanian,
They never really can waive a right that doesn't belong to them.
Right, so that's
Well,
the
that-
preemption.
but that's the preemption part.
But now it's the United States saying the California Supreme Court got it wrong. So it's a battle between the Supremes and the feds always.
So,
If the federal law speaks about the same subject, then it preempts, but it doesn't.
well, that was
Because it
in
never
the
speaks about
interesting
the
question.
penalties. Yeah.
That
And there
was,
a solution.
so that's the one that really is addressed in the Adolph case. And when I just read the headlines about the Adolph case, I was confused because how can the California Supreme Court decide something when the United States Supreme Court has said that the Federal Arbitration Act preempts it? How can the California Supreme Court override that? They did it by turning around and saying the PAGA claim is a state law that must be interpreted according to state law and by California judges. And you cannot override and take away that right. They went back to Iskanian for the individual right and held that you cannot be forced to arbitrate the representative PAGA action in front of the arbitrator. In Adolph, I'm going to read to you the actual, maybe I'm going to read to you, right, page 4. The arbitration agreement that Adolph signed said, with respect to PAGA actions, to the extent permitted by law, you and the company agree not to bring a representative action on behalf of others under PAGA in any court or in arbitration. And this was called the PAGA waiver. The arbitration agreement also included a severability clause that said, hey, if any part of this agreement is unlawful, we can cut it away and enforce the balance of the agreement. And that severability clause was what the court looked at, the California court looked at, in deciding that the PAGA claims could be preserved. Because you cut off the part that says, and you can't act in a representative capacity. So the individual claims, still arbitrable, but the representative claims are not bound to the arbitration agreement, and PAGA still is a California law that must be enforced by California decisions. Iskanian rises. And the court in the Adolph action said there are a variety of ways this could be handled. You can file both of them, one in arbitration, individual claims, and one in state court. And then the state court claim can be stayed until the arbitrator decides whether there's a violation. If there is a violation, the employee is going to per se be an aggrieved employee and be able to be the representative for the PAGA action. Once the arbitration decision is rendered into a judgment, then it will be binding on the state court in the PAGA claim. If the arbitrator decides that the employee has not been wronged, then the PAGA claim is going to evaporate because there is a judgment, which also can be, there's a decision which can be rendered into a judgment and would therefore be binding on the PAGA action. So that's the way that they expressed these procedural difficulties you have by filing in two separate fora, one for the individual claims and one for the representative claims. I know that's clear as mud.
I think it's the correct result.
I'm sorry?
I think this is the correct end result.
You think it's the correct result? And you're on the plaintiff side.
I'm mostly on plaintiff side, but like just reading the state law, it's a matter of law. PAGA is the law.
PAGA is the law, and I think they're right. I do think they're right.
The Supreme Court can.
I think Iskanian is correctly decided. I don't think that because the employee is stepping into the shoes of the state when they're taking the PAGA claims, I don't think you can have them decide that they're not going to step into the shoes of the state on a contractual basis that doesn't include the state. And the state still doesn't have, despite having a PAGA enforcement group, does not have the resources to go after every employer that is not paying overtime or has donning and doffing issues or not providing meal and rest periods or not putting all of the information that is necessary, paying under the table. That's a lot of these cases, is paying under the table. And there should be a way of enforcing those laws, in addition to getting what is due to you under the statute, which would be the arbitration or class action. Yeah, you can agree not to be a class representative.
You know, and I agree that Adolph is properly decided because the whole point of this was to have fundamental fairness and a fast and efficient processes for adjudicating these types of claims. So it just seems like it took a while, but we're back to where we should be. So I agree, I like this result in Adolph, restoring that was dubious under the previous case, Viking Rivers.
And are we going to see more litigation?
Absolutely.
Is that a rhetorical question?
One can argue that these representative actions are an efficient way of coming to the end of the dispute. And in one fell swoop, with the threat of the stacking penalties, an employer can wake up and fix their practices going forward.
The concern that I have for some of these things, like what's printed on the paycheck, pay stub, it's consistent all the way across. But remember, this is a representative action. They don't have to prove the same thing that has to be proven in a class action. So if you've got an employer that has multiple locations, and location A and C are not providing meal and rest periods, but locations B, D, and E are providing meal and rest periods appropriately, in a class action, you have to prove that everybody across the board is more likely than not getting meal and rest periods. In a PAGA action, you don't have that level of proof. So I think that there is a bigger hammer with PAGA for things that may not be consistent across the board. And that's the one problem that I have.
So then I will think of this point.
I'm sorry?
What is an employment lawyer's responsibility to the client? Because a lot of these cases are filed as a PAGA-only case, right? You file it for the individual's wages, 65 days later you amend in the PAGA claim, and you're hunky-dory, you're gonna have, what did we get, 800, when you were an expert, that $800,000 per judgment that we will never enforce a penny from, but it looks good on my website. But at the same time, I find it only as a PAGA because my client didn't work there more than a year. Heck, didn't even work there a quarter. But if I have a client who worked there 4 years, don't I have an obligation to file it as a class action? Then I have to meet those requirements.
But not for the PAGA.
No, not
So
for
if you've
PAGA,
got a
but-
situation like in Adolph, where the PAGA is separate, and they discovered that, or decided that your employee or former employee is aggrieved, then they may end up getting the PAGA penalties for everyone, regardless of whether everyone experienced the same wrongs. Because the wrongs differ from place to place. I think we cut you off on a question, Anthony. Now you've forgotten.
No, do you have the definition of, like, what is an aggrieved employee under the PAGA in mind? Because I remember reading this case and thinking aggrieved employee was extremely broad. And that even if the employee lost in the arbitration, they still might meet the definition of aggrieved employee, because I don't remember why I thought this, but I just remember the definition was broad enough to where maybe you could lose and still have a PAGA case, even though you lost in your individual claim in the arbitration. I might have misread the decision though.
Okay, here it is. 1, someone who was employed by the alleged violator, and 2, against whom one or more of the alleged violations was committed. So if your employee loses at the arbitration because none of the violations they alleged happened according to the arbitrator, the fact finder, then they are not an aggrieved employee. Somebody else in the company may be. Just not your client.
Yeah.
So let's talk about some practical ways to deal with this. We didn't decide who was to handle which one of these.
No, we'll just jump in.
We'll just jump in.
Yeah, go for it.
Okay, so one question that an employer must have in its mind is whether they're going to even try to require arbitration of PAGA claims, or arbitration of cases with the possible result of having to litigate in 2 different forums. It may depend on the size of the workforce and whether the employer believes an arbitrator is more likely to accept the employer's behavior and or find the employee is an aggrieved employee. If you have a workforce of 10 or 12, you're not going to likely get a class certified anyway, because that's the small enough size that the court's going to say, don't need a class action. Anybody that's got a beef can bring their own or join in this. You may end up with 6 named plaintiffs out of that, but you don't need to have a mandatory arbitration agreement. And so that's why I think the size of the employer, the care with which the employer enforces and adopts its policies is going to play to some extent, although even the most careful employers can be found to have made mistakes. Something is wrong with this slide. I don't think. Yeah, sorry. What's going on? All right. So this should say employer considerations include but are not limited to whether to include a severance provision in any arbitration agreement. I think in general, it's a good idea to include that. Back to that, if somebody decides one of your provisions is showing unconscionability and you've got the severance provision, then you can more easily strike that provision and enforce the arbitration agreement. And then trying to compel arbitration of the PAGA claims with the result of having to litigate the claims twice. If one proceeds in the state court and one proceeds in arbitration, it may be better for you if you think you're going to defeat class certification or you've got a narrow, confined claim, just to say, we're not going to arbitrate the individual claims or the class action, or particularly if they've waived a class action, so you've got the individual claim and the PAGA claim, just litigate it all in Superior Court. So look at what the employee is claiming, look at the potential for defending them, look at the potential for the employee bringing a class action plus the PAGA claim, or is it really an individual claim plus the PAGA claim? And that may be the deciding factor. It's the biggest deciding factor in my mind in handling these cases. Sorry for the mess up in the slides.
No, that's, so anyway, some other considerations are, have those, can we decide on how to say armament? So we talked about those in the previous slide. So what are those requirements present? So you want to make sure that that when you're looking at drafting your arbitration agreements, that they have the essential requirements in them. And then we talked a bit about the unconscionability. So you want to look at both procedural as well as the substantive unconscionability, to remind you of that discussion we had.
And that is really going to depend on having a conversation with the employee. Was this shoved under your nose? Did you have a chance to review it? How big was the type if they were looking at it online? Did they really twist your arm into signing it? Did they suggest that you would not be welcome to keep your job if you didn't sign it? So that's got to be discussed with the employee because this is all about fairness. Did they knowingly enter? And there are cases there where very sophisticated employees, C-suite or just below C-suite employees, looked at the arbitration agreement, asked to change it, and the employer would not, and that was found to be unconscionable. So did they have an opportunity? Did they try to change it? Those are the kinds of things that you need to talk about with your client.
I think it's such a sticky wicket, because most of the people that I talk to say that they didn't have a chance to enter into a dialogue, and they're fearful if they don't sign the document, they're not going to get the job. So they sign it as is because they want to get to work and start earning money. It would be great, and I think that is spot on advice of what good employees should be doing, so that at least it's documented that discussion happened. I just don't think the individuals, the employees, do that. And they don't even say, stop, can we just time out and go talk to somebody? Call Maggie, call one of you and say, what do I do in a situation like this? I think the pressure is so great that they just sign on, but I think it is prudent to try to have that dialogue. I think the employer is also going to be thinking about, well, if I do a little carve out for John, then I have to do that for Nancy, and before you know it, there's no consistency in my enterprise. How do I manage that with respect to my aversion to litigation? The whole point is to try to get a handle on that. And
So my answer to
so
that,
what-
if the
what's your-
employer
yes,
raised that with me, is these are concerns about things that are really unlikely to happen. Because you're going to try and be a good employer, and you're going to try to work with your employee and keep them there and document it. And this only comes into play if there is a lawsuit. And we're going to work around any bumps in the relationship and avoid the lawsuit. And if you've got a little difference here or there, no matter what, you're going to have to present it to somebody to see if it's enforceable, who's going to be deciding if it's enforceable. And it's more likely to be enforceable if Marta says to me, I don't like AAA, I want to go to JAMS, and I put it in JAMS.
right.
And so that's the answer to the employer's concern, in my humble opinion.
And anything that makes it looks arm's length, I think, is to the employee's advantage for sure, and certainly the employee's advantage as well. Couple of other things, does potential PAGA recovery warrant the expense of litigation in multiple fora? As we were talking about earlier, you have to, in your analysis, think about, you could have a PAGA action, you could have a court action, all of these things going on, at the same time, the expense of it, the disruption to your business when you've got all this going on. So these are things that you really need to be thinking about in your analysis. And can these PAGA claims be brought in a separate action, as we've already discussed?
And the more jaded side of my, having represented 75% of the time employers, says, you got the right to recover costs and attorney's fees in either of these actions, so is there ever really going to be a time where the expense outweighs the value of having both cases? But for smaller law firms,
It does.
it does, because this is your attorney time and your attorney stress and the lack of bodies that you have to throw at it. And you may be going up against an international law firm that's going to throw 7 associates at it and try and do depositions all around, which is going to be a real stretch, which is why there is a cadre of plaintiffs' employment lawyers in Los Angeles that all work one another's cases. And they're not a law firm, but they pop up on each other's cases because each firm only has 3 to 5 employers, and they can't really litigate, and they don't know which of the cases is going to hit.
I have to share with you a mediation that I had. 50 employees, roughly. They filed a claim and a PAGA claim. There's a arbitration agreement and a mandatory mediation agreement built in, okay? So they started off with a class action, and Viking came along and they threw out, couldn't do the class action. So the employer's attorney filed 50 separate arbitration claims
Wow.
and demanded mediation on every one of them. Okay, and imagine the cost of all this,
Yeah.
okay? And then they go to the mediation and they say, well, we're just doing this because we're mad. They actually say that. But I mean, so when you look at employers trying to save money and trying to do the thing that's best legally for them, whoa, hear a case like that, and you have to really wonder.
I still would not be surprised if in the employers, if it made a bottom line difference to the employer. Because if they can resolve 50 cases through mediation, each one of
But they would
them,
mediate, that's the whole point.
They-
Plaintiff's attorney, but they went to the mediation,
But
but
they
they refused to really participate. Yeah, they told me $500,000, and I
But
said, well,
isn't that agreement requiring them to mediate in good faith?
But what can you do
What can
when
you do?
somebody doesn't
You can't-
mediate
you
in
can't
good
talk
faith?
about it.
Yeah,
The
they
mediation
said,
kind
well,
of-
we think that the damages are $500,000. And I said, well, and then they have a bunch of phony baloney stuff and.
The confidentiality, the mediation confidentiality provision means that you have no teeth in any agreement saying someone has to mediate in good faith, because you can't come forward and say their behavior at the mediation was not in good faith.
Yeah, how do you define good faith? It's such a hard thing
And,
to really.
and it is my good faith belief that each person is entitled to $500,000.
Exactly. So
Yeah.
it's
Yeah.
tough.
That's what they said. We think we're gonna get all these penalties and yada, yada, yada.
I have
$800,000.
be interested to see what people's thoughts are on this, because I have recently stolen lately a provision from lease agreements that says, thou shalt mediate before filing, and if you do not mediate, you do not have the right to recover attorney's fees. Is that going to be enforceable in the long run?
I think I've seen that too.
Anybody have any ideas?
I think the state law would supersede whatever you wanted to put in your agreement. And so putting in that you lose your right under, labor law to recover attorney's fees if you don't follow this particular requirement of ours, somehow I think would not last very long.
In landlord-tenant law, there is also a right to recover.
Right, but it's not under the labor law. Labor law is giving you the right to recover.
But the landlord-tenant law statutes say that when there are certain kinds of recovery available, that the tenant can recover attorney's fees.
But this, I think it's very different. But I think one of the concerns as a mediator that I have is that I consistently see the opposite of what the judge sees. I see small actions against a small employer with a PAGA claim just written right into the complaint, none of the filing that was supposed to take place, and when they settle it, they say, oh no, we'll just release the PAGA claim. And so it's kind of it's nonsense. But the other thing that I think is we are being conditioned by all of these apps where you agree to the terms and conditions in order to get your little app that shows you the map of the trail you're going to walk on. Agree, yes, agree, yes, thank you. And so employees, imagine, we're pretty sophisticated in this room and we're all doing that, agree. People who are waiting tables or
Changing tires.
changing tires are not scrutinizing all 37 pages. They're hitting agree, and getting their job. I think it's absolutely no way to say that they fully understood and had volitionally given up their right to trial if they're.
That's why I have pull-out sections that are initialed, which are just in bold and short.
But
But they will still.
You still just click it.
initially.
You're saying that there's such duress in that initial stage of that they have to click agree because
Yeah, yes.
they're trying to get to the.
And it's not even,
To the job.
it's not external duress in the sense that I'm standing over you saying,
Yeah,
you've
not
got
like
to do
that.
it.
No, just the economic. Yeah.
It's the way of the world. And,
Yes,
you
yeah.
buy a house or sell a house and you're there on DocuSign going initial here and initial there. And I've been practicing law for 43 years and I'm sitting there initialing here and initialing there.
Right. It always gives me some kind of like, oh my God, what am I signing my life away? But what choice do you really have? It won't even go to the next page if you don't.
They won't go to the next page,
I
exactly.
think there was a decision that said that unconscionability requires more than a mere contract of adhesion. It's requiring such like tilting of the scales in favor of one party as opposed to the other.
And just so you know, that if you
Right.
object to those, they will print it out for you and you can strike things out.
I'm talking about real life, okay? And,
Nobody does, but they have.
Except me.
to.
Yeah. I do like the comment that you made about kind of looking at it comprehensively, like it's more of like a sliding scale sometimes between, the procedural unconscionability piece and also substantive unconscionability, kind of looking at it like in total to see if it's truly unconscionable or there's just some disagreeable aspects to this thing, but it doesn't necessarily, or it may rise to the level where you can determine, yes, this was truly unconscionable. I think it's a gray area, it's a fun area to talk about when it's not your life in your case, but it can be very problematic, I think. So you can only take these like safeguard measures that we've been talking about to try to hedge your bets that you can at least prove if it ever becomes an issue that you can say that you had a discussion, you at least gave it some kind of specter or some kind of a veneer of equal or fairness and equal bargaining power.
I've seen some fairly good arbitration agreements lately, just kind of an improvement. And they really work really hard to make it one page. Great. And all of my clients sign it because they think in the large scheme of things, the odds that they would have to sue doesn't, and if they have to sue, then they will sue in arbitration. They don't realize that many plaintiffs' attorneys simply don't take clients in arbitration. Or, I mean, I have it in my fee agreement that if I discover that they have an arbitration agreement, I have the right to withdraw. I never do, because like then what's going to happen to the poor client? But I think it just makes the plaintiff's attorneys work twice as hard for half the money. So it's a quarter of the recovery.
I have found that in single plaintiff cases, particularly for small to medium-sized employers, the arbitration agreement really is a tool that is used to hammer the employer into settlement, because the arbitrator's fees from the get-go are going to be,
10,000.
if you 10, I had one that went 50.
Ooh,
Yeah.
I'd like that job.
I was having the wrong business, but I'm the right business.
Right, let's talk about your fees.
We knew it would be a multi-day arbitration. Probably, I think it was 10 days or something, and she wanted 50 up front. And so.
I'm not doing this until there is 50.
And there are times when arbitration is better for the individual because somebody's making $350,000. You get in front of an Oakland jury or a Contra Costa jury, they're going to go, hoo, you had it sweet. And they're not going to award that. But an arbitrator who has been practicing law for 30 years and has seen $600,000 incomes in managing partners is not going to bat an eye at 350. And so that's a place where both parties want to be in the arbitration. Back to PAGA claims, I think that there are times that it really is not worth having a PAGA claim. If you've got a plaintiff who's got a long period of time in employment and you can have a long period of time with multiple claims, because you can settle that without having to go back to the judge. I think it is underhanded to try to avoid going to a judge when you've got, I'll just dismiss the PAGA claim. It used to be that happened. And I just think it's a violation of the law. And I don't know what happens to my little employer if the PAGA claim is not documented and blessed by a judge. And we settle to somebody else, then have another PAGA claim because this one wasn't really settled according to the code. So that's something that you got to weigh what the benefits and drawbacks are of bringing these kinds of claims on both sides.
Because I have a duty to zealously represent the client, and it's hundreds of dollars every paycheck.
The PAGA claim itself, you don't represent the Attorney General.
As soon as I file, I do.
If you file, that's the question. Do you file it? Or do you
But
talk
do I
with your
have
client and say,
Do I have the luxury of not getting that 25% of the agreed employee fees
well,
for my client who is here in my office?
that's what you have to analyze with your client. Is the time that it's gonna take and the hurdles we're gonna have to jump through worth it to you?
Practically, I agree with you. I don't know if the ethics rules allow me to agree with you, although
Interesting.
in this case, I would probably violate the ethics rules.
I was wondering about that too, the ethics of dismissing the PAGA claim.
Not
Not
dismissing,
filing.
not filing from the outset.
And then the client finds out that, or
Well,
not
you
finds
don't-
out, but just backstabs me to the bar, which does happen. in
I
plaintiff's
think you have to
agreement.
discuss it with the
There was
client.
some kind of
Or
waiver.
they will forget,
Oh, I think they wouldn't.
or they forget that there was an email even. I'm dealing with a client who is saying I did not communicate with him and I have stacks of emails. So this is gonna be so fun.
Well, you know,
Please tell us how, says the state bar. Please, did you not communicate with the client? Please tell us why you did not communicate with the client. Please.
yeah.
Does it matter, like, in terms of how far along you get in the PAGA claim, if the court has to approve the dismissal or not? Or, it might depend on what you ask for in the release as the employer, right? Like I think some of the cases I've seen, people kind of throw in the PAGA claim as like a tack on, trying to get more leverage, but they really just want to increase their leverage for their individual settlement and not actually like,
And I think
Are
those are the
serious about-
kinds of, that's the kind of case that the PAGA claim has, once it's filed, it has to be approved by a judge before it can be dismissed. And I think judges are getting more savvy about that. I had one of these cases where they filed in two separate courts, and in mediation, all of the cases were settled, but they're still pending in two separate courts, and we had a case management conference, and the judge said, you need to file, we told the judge in the case management statement that there'd been a settlement, and you need to file for approval of the PAGA settlement. And that was just the PAGA. That was his reaction immediately. So I think that's something that you have to be aware of. There's a cost, and if your client worked there for 3 months and their penalties are a couple $100, the cost of filing that PAGA settlement is going to eat up his settlement anyway. So there's a case where,
No. My client worked there for 3 months,
yeah,
but there were 30 employees working
Yeah.
there for a year.
What about all that?
but
And they have, this case, they have weekly paychecks. That's 52 times at least 100, even if they are all initial violations, which some attorneys argue, until my PAGA letter arrived. So it's a lot of money.
for whom? Doesn't that get distributed by through the aggrieved employees?
25%.
But throughout the aggrieved employees, based on, but your individual client's share would be based on his,
Yes, but I'm
Duration of discipline.
representing all of them, aggrieved employees too.
well, you don't represent them.
Okay,
This is
This is the question.
these are the things that have to be
So
looked at, that's all I'm saying.
Stack up because they did not change any of their practices till today, and it went on for 3 years. It stacked up to $729,865.79.
Across the group of aggrieved employees.
Oh, yeah. And because my client was driving car number 29, the assumption was there are at least 29 cars.
Okay, I'm just saying these are issues to look at. And I understand you have a very strong disagreement with me.
No, naval gaze on these, yeah, I just don't know, I mean, in terms of, because this was brought up in that PAGA conference.
So I will close with one, what I thought was a horror story. There was a case that was both a class action and a PAGA case. We settled it early on before either side had done a whole lot of work. I think my fees were about $15,000. And in order to get the settlement, I had to agree not to oppose the other side's application for attorney's fees. and the other side proportion of the attorney's fees was 45% of a fairly large settlement. And so I did not oppose it, but I thought that the judge might look at it and think it was a little overreaching. So we get to this small town, and it was a small town court in Western California. And I'm waiting and waiting and waiting. There would have been no tentative ruling. And everybody leaves, and the judge says, "What are you doing here?" And I said, "I'm here on this case." And the opposing counsel says, "We're both here on this case. We had the hearing on proving the fees on the PAGA settlement today." And the judge said, "Well, I haven't seen the papers." And he picks them up, and they're this thick. And he goes, "Well, it's unopposed. I'll just grant it." Whoa, please read them. But I couldn't even say that. So I think that judges today are more attuned to PAGA actions, particularly in the Bay Area. And they are interested in seeing fairness, and they are interested in awarding penalties and attorney's fees and making sure that at least the Bay Area employers are crossing their T's and dotting their I's. So we are right about at our end. Any further questions? Marta, thank you for making it interesting.
You are always interesting. Oh, I have a question. Okay, this is an interesting one. So you send a letter to the employer, send a copy to or file it with the LWDA, and then 65 days passes. Are you required on the first day, on the 65th day, to file a lawsuit? Or what happens if, like, is it the 66th day that you have to file a lawsuit? What happens if there is a delay between the 65 days and the filing of the lawsuit?
The way I interpret it is the tolling that started when you notify the LWDA and the employer lasts for the 65 days, which is the period of administrative review. And on the 65th day, the tolling ceases, so that your limitations period starts to become shorter. If you file on the 75th day, your limitations period is then 5 days shorter. That's the way I read it.
5 days shorter than, or did the 65 days as if it didn't even happen?
No, it's tolled. I think, the way I read it is that
But
it's
the tolling
tolled
ends.
for the 65 days, but the tolling ends. It doesn't evaporate.
Okay. So I went to a PAGA conference, and one of the speakers, who was from, I believe, Littler or such like, Jackson with all we do is work or whatever.
Oh,
Said
that's not
that
Littler,
he
that's,
thinks it evaporates, that after 65 days, it's if you file it on the 66th day or a day late, $1 short.
Sounds like it eventually.
Right? I was like, I like how you think. Can you please think on my side for a second?
yeah, we make all sorts of arguments. I think, I have been told by judges that I have balls, and I think that would be a pretty ballsy argument.
What is the other thing?
Okay, well, we have another program. Thank you all for being here. I hope we met your expectations.
Let's try it then.
And you didn't see me cry this time.